The nation is shocked with yet another reported rape case. Hi, I'm Monica Singh from Law Answer Online, a platform that answers your legal queries. We have been receiving a lot of questions regarding the legalities around rape cases. So we have invited Ms. Krishna Parkhani, a lawyer by profession, to answer them for us. Thank you, Ms. Parkhani, for joining us.
Thank you for having me over, Ms. Singh.
Okay. What are the legal remedies available to a rape survivor?
The legal remedies available to a rape survivor at the first instance would be that she can file an FIR under Section 154 of the Code of Criminal Procedure. Section 154 has recently undergone an amendment which prescribes that the FIR for offences of rape would be recorded by a woman police officer. The same would be videographed. In case the victim cannot make it to the police station on account of physical disability, then the police officer can go to the residence of the victim or to the hospital if need be. Furthermore, when there is a problem with respect to registering the FIR under Section 154, there is an option to approach the Superintendent of Police in writing. However, this is a case of cognizable offences, and taking into consideration the judgment in the case of Lalita Kumari versus State of UP, which squarely covers cognizable offences, the police is bound to register an FIR.
How to get a FIR registered?
As I stated earlier, we have the provision of Section 154 available. However, sometimes there is a problem with respect to the jurisdiction. Therefore, it is important to emphasize on the need for zero FIRs, which means that the victim can go to any police station of her convenience and have the FIR registered. FIR simply means narration of your ordeal, and a police personnel would be recording the same in the written mode. And if there is a problem with respect to the jurisdiction regarding the FIR, the same is an internal matter of the police station, and it would be transferred by the place at which the FIR has been recorded to the particular jurisdiction as required by the police itself. In case, however, there is a problem with recording the FIR, despite the Lalita Kumari judgment, then you have the option of approaching the magistrate under Section 190 of the CRPC.
How does delay in FIR affect the case?
The offence of rape is the offence against the body, and a conviction for rape primarily depends on forensic evidence, especially in the form of bodily fluids, hair, fingernails, and DNA samples. And this valuable evidence would be lost depending upon the delay in filing an FIR. Though I would also say that sometimes, based on the stellar testimony of the victim, one may see a conviction through, but often there are issues also with respect to the time lapse leading to a delay in investigation. And at the very least, it is the accused who would be at the advantage of fleeing without an FIR being registered.
What measures need to be adopted while the trial is pending? What is fast track court?
For certain offences, taking into consideration the pendency of cases in various courts, fast track courts have been established to ensure an expeditious trial. For instance, with respect to sexual abuse of minors under the POCSO Act, as well as for the rape victims. Now, I would take the first part of your question with respect to what are the various measures one needs to be cognizant of in a trial. Though the 2018 amendment specifies that an appeal has to be heard in 6 months, this rarely happens, and a trial is a long-drawn process. Therefore, it is often that witnesses become hostile, and even the victim might want to detract from her statement. Therefore, it is essential that you have the victim compensation and the witness protection scheme in place. The witness protection scheme has garnered the assent of the Rajya Sabha in 2019, and this was propounded in the case of Mahendra Chawla versus Union of India by the Supreme Court, which ensures that witnesses have adequate protection and they are not being threatened and intimidated or coerced into changing their testimony during the course of the trial. The next part of this answer would be the victim compensation scheme. Section 357 of the CRPC provided for victim compensation. However, there was an amendment in 2013 and 18 which introduced Section 357A, B, and C. These provisions are slightly different from 357 because 357 comes into play after the conviction of the accused, which would be easily for a period of 2-3 years that the victim would not have access to any funds. However, under the latest provisions, one can approach the DLSA or any other state legal authority services as applicable based on the application moved before the court at the first instance, and the court would recommend that victim compensation is necessitated in this particular case. Furthermore, provisions are there with respect to providing timely compensation for the physical and mental rehabilitation and treatment cost of the victim as well, to ensure that the victim can come out of this heinous offense. Also, there are provisions that specify that under Section 357 now, the legislation has distinguished between the compensation that is provided by the state, that is the government, and the compensation in the form of fine that would be payable by the accused after conviction takes place. Therefore, the legal remedies available to the victim during the course of trial would be witness protection as well as compensation at various stages to ensure that she can undergo and get rehabilitated after this heinous offense.
Okay. Are there any recent changes in rape law?
Since the Nirbhaya case, there have been certain instances of amendments to the ITC as well as to the Evidence Act and the CRPC. And the most recent amendments have been in 2018, whereby we see that now women police officers need to record offences with respect to sexual abuse of women. Also, we see the amendment to the provision of rape itself, which now allows for conviction and trial of offences with respect to minors as well. The penalties have been enhanced. Death penalty has been added under certain circumstances. This includes the rape of a victim below the age of 12 years and gang rape of a victim below the age of 12 years. Further amendments have also been brought about with respect to Section 438 of the CRPC, which ensures that no bail can be granted to an accused of rape without hearing the victim. And we see that there are provisions with respect to trials taking place and appeals being heard in a time-bound manner.
Is any private video of the rape victim in which she is stating about it before her death admissible in court as her statement or evidence?
Victim's video would be admissible as evidence or her testimony depending upon the facts and circumstances of the case, taking into consideration that whether that video is considered authentic or not based on forensic evaluation. And also, one must be cognizant of the Evidence Act with respect to electronic evidence and admissibility of electronic evidence under Section 65B. Now, getting into the finer nuances of whether such a video would be admissible, there is a provision under the Evidence Act called the dying declaration, and if this particular video would be considered dying declaration, then it would have an important role to play in the trial and conviction, because this would be considered as the last words of the victim. However, all this depends upon the facts and circumstances of the case and whether or not that video is deemed authentic by the court.
Okay. Is there any difference in punishment if the victim dies at spot or later due to the injuries because of rape and if she is living?
Yes, there is a difference because now the provision specifies under Section 376A that in case the victim dies on account of her injuries, then the penalty would be double as compared to Section 376 of the IPC. Under 376, the tenure of imprisonment is 10 years, further extendable to life with fine. However, when it comes to Section 376A, there is a provision that the minimum sentence would be 20 years and it can be extendable to life imprisonment. There is no scope for remission in this particular offence because the legislation is explicit and clear in stating that in such a situation there will be imprisonment for life, which would mean that imprisonment would be for the natural tenure of that person's life. And also the death penalty is available at the discretion depending on the facts and circumstances of the case.
Please tell us about the provisions for sexual abuse for minors.
We have a special legislation enacted for the conviction and trial of offences against minors, that is the POCSO Act. There are provisions with respect to various offences like penetrative assault, sexual assault of minors, and these would primarily range from Section 5 onwards. However, there is an amendment in the Indian Penal Code as well under Section 375 and 376 of the IPC, which now specifies that a higher form of punishment is available when it comes to prosecution of offences under the IPC when it comes to the victim's age being less than 12 years. And also the amendment extends to gang rape of victims below the age of 12. And the provision of death penalty is applicable to these circumstances, which is a higher form of punishment as propounded compared to the POCSO Act.
Is promise to marry and failure to marry equivalent to rape?
Everything depends on consent when one has to adjudicate upon a matter of rape. Therefore, what matters is how the consent of the victim was obtained at the first instance. Any consent obtained with duress, coercion, undue influence, misrepresentation would be deemed to be void, and it would lead to the accused being vulnerable to the prosecution under rape. However, if the consent was free and willing, and due to other extraneous circumstances, the particular relationship did not culminate into marriage, then in these situations it would not be a case of rape. And we can see this particular reasoning being propounded by the Supreme Court in a recent judgment of 2020 itself. Therefore, what matters is that it is the facts and circumstances that govern how a particular trial for sexual offences would go about.
Thank you.
Thank you for having me.